District Court of Greenwood County, Kansas. This matter comes on for review in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paul E. Dean appearing for the state, Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car a plate that you had ordered specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and that was manufactured at your request by a private vendor, and you were found guilty, and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. Then you filed some motions for today, but the main concern is you need to either pay or perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that notice of appeal. So you started the appeal process, but typically they don't accept those until or unless accompanied by an appeal bond. And you did not pay that cash bond, did you?
No, I didn't. I actually did the
Asterisk, strap in, folks, because today we're diving deep into sovereign citizen delusion. Weiss. First up, a courtroom showdown in Kansas featuring a man named Abel Estrada, who decided state laws don't apply to him, but still wants the state to pay for his appeal. You heard that right. After being convicted for using fake license plates he bought from a sovereign citizen scam vendor, Abel now thinks he's entitled to a free ride through the appellate process, courtesy of Kansas taxpayers. And just wait until you hear his arguments. They involve straw men, commercial contracts, and something called living man status. Yeah, it's that kind of party. Asterisk, then, we pivot to Michigan, where a man named Robert Chan walks into court with all the confidence of a bar exam flunker holding a thesaurus. He's facing felony check fraud, but is more interested in challenging the prosecutor's fiduciary trust obligations under the alleged bankruptcy of the United States. Spoiler, that's not a thing. These two hearings are packed with everything legal. Nonsense, dramatic shutdowns, and judges who've clearly had it. Get ready for one of the wildest back-to-back sovereign citizen courtroom faceplants we've ever covered. Let's jump in. Asterisk.
Has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it, etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case, and let me see.
If I may.
Well, I show the journal entry of trial. Let me see if it was filed February 21st. And that shows that he was found guilty of displaying unlawful tag.
I think he's still within his 60-day docketing time period. So
I think so too. So Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the I just needed the signature on the papyrus forma pauperis. I don't know if you can see it.
No, we can't. Why don't you read it to us, Mr. Estrada?
Oh, I don't have my glasses. Well, can you read it for me? I have my glasses because I don't have my glasses. Yeah.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark March
Hey,
30.
ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muff.
Asterisk. So here's the scam. Abel Estrada was caught driving around with a knockoff license plate made by another sovereign citizen. Instead of complying with the court's ruling, he's trying to finesse his way out of responsibility with paperwork and technicalities. But the real kicker? He wants a free appeal. It's like breaking into a store, getting convicted, and then asking the same store to fund your complaint. You can't pretend the government doesn't exist, and expect it to bankroll your defense. That's not sovereignty. That's freeloading. And notice how the judge isn't even entertained by this nonsense. It's all procedural. All by the book, but you can feel the irritation boiling underneath. Asterisk.
Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in forma pauperis, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have submitted will be held by your office on your behalf.
Asterisk. And now we get what might be the most unintentionally comedic moment of the hearing. Abel can't read the court's letter because he forgot his glasses. So naturally, he brings in his wife to read it for him. This is courtroom strategy. Straight out of a sitcom. Not only is it completely unprofessional, but it reinforces just how unprepared these sovereign citizen defendants really are. They can quote fake laws, talk about straw men, and throw around common law buzzwords. But they can't follow basic procedure or bring reading glasses to a Zoom hearing. Let that sink in. These folks aren't fighting for freedom. They're fumbling through fantasy. Asterisk.
And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it. I mean, it does it. I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment, doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided nothing to the court to make that consideration, or whether he's asking the court to waive the appeal bond. It doesn't say that either, but those are the three logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform and under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man. Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it. So motion to dismiss liability, whatever in the world that's intended to be, is hereby.
And or the payment of costs and fines.
That's what that was. Okay.
And the payment of the appeal bond. So I believe that was a late April date on the perfecting the appeal. So I would ask the court to set this over to someday in early May.
Asterisk. Here it is, the holy grail of sovereign citizen word salad. The straw man theory. Abel Estrada claims he is the living man representing the straw man known as Abel Estrada Jr. He even signs the motion as the authorized representative of himself. These pseudo-legal arguments have been debunked in courtrooms dozens of times. But that doesn't stop people like Abel from throwing them at judges like legal spaghetti against the wall. And this judge, he's not having it. He denies the motion, outright calling it nonsensical, because it is. You can't separate yourself from your legal identity to dodge responsibility. That's not how any of this works. Asterisk.
As for the records, I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, "Do I need to send one directly myself, or do you get a copy?" I'm talking Mr. Dean, the judge and Mr. Dean gets a copy, and they say, "No, don't worry, they get a copy." So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record?
Who is the court of record? Is that the district court? Is that the
District court.
Court of Appeals? Did you send it to the clerk? You sent it to the judge?
I send it to you directly, magistrate, and I send it, I put it on the court of record.
Time, and it was premature. You shouldn't have filed that, so that was removed. Missy, didn't you show me that he had brought something into the office, but I'm not seeing it in the file. I don't know what he brought in. Do you have that, or should I have that somewhere? It seems like I saw something that he may have. Missy, are you there?
Yes, I'm here, Judge. I can see there was a paper. Let me go see what it was.
See if it's at the clerk's office. But as far as the informa pauperis, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney, since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an.
Asterisk. This part is just sad. Abel insists he sent the paperwork but can't tell the judge who he sent it to. The court of record is not a person. It's not even a helpful phrase. It's clear he has no clue how service works in the legal system. No certifications, no copies sent to the opposing counsel, nothing. He's treating the justice system like a vending machine. Shove in a few buzzwords and hope a dismissal comes out. But as the court keeps reminding him, that's not how appeals work. If you're going to play lawyer, you need to know the rules of the game. Asterisk.
Filing fee.
I'm requesting the papyrus because it'll cover it. And then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request. And all I need is the letter that I submitted, which is, for some reason, they're asking for you to sign. So I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to, the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that we've received his copy of the of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge Webster, and their addresses and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address, but in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address.
You understand also the challenge of the crime that you're charged with?
Yeah, I don't understand.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st.
Asterisk, just when you think it can't get any more bizarre. Here comes Robert Chan. This guy walks into court by special appearance, claims he's the attorney for the all caps version of his name, and refuses to consent to statutory authority. If you're new, hear yes, this is a real thing sovereign citizens believe. They think that by arguing capitalization or jurisdiction, they can nullify real-world laws. It's like showing up to a chess tournament and demanding to play Uno. The judge, thankfully, isn't buying any of it tanned. It's clear this courtroom is about to go from nonsense to nuclear.
You do? Yes, I do. But I won't be able to help you with that. Right. You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself? No. Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
The prosecuting attorney is capable of even speaking in this matter.
I'm not sure if that's what you mean. My question was about a preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but do you have any questions about this preliminary exam?
No.
Knowing all of that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States?
Asterisk, and now we enter peak sovereign territory. Chen launches into a bizarre theory involving the bankruptcy of the United States, fiduciary bonding, and whether the prosecutor is acting as a trustee. Says sovereign citizen Mad Libs at its finest. He's clearly read a handful of conspiracy blogs and thinks he's cracked the code. But the prosecutor fires back with cold, hard reality. She's licensed, authorized, and prosecuting under state law. Period. The courtroom is not a YouTube comment section. You can't argue your way out with buzzwords and fake legalese. And once again, the court shuts it down, gracefully but firmly.
Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I've reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Do you have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records,
Which records?
my court filings,
Your court filings?
yeah, that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here. With me. Did you get anything?
I did not hear it.
Did you want to review this?
May I approach your honor?
Any response to what he's talking about?
Your honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore,